Right, Honourable Speaker, this judgment was given inter partes. Government was represented in a court. Number two, we no longer, by the way, extract decrees. Chairman Mao, my colleague, we no longer extract decrees for purposes of execution. Court decisions by nature, especially at the level of Supreme Court, are self-executing. You don't need a decree to act. So if judgment was passed inter partes, what more are you getting from a decree? What exactly more are you looking for in a decree? So I really think that perhaps we could use other arguments, but let extraction of a decree, by the way, with or without a decree, that judgment is self-executing. You ought to have acted even without any hesitation. Unfortunately, because you see the danger with mentioning the decree, you have many other people who are affected by that decision of the Supreme Court who don't have lawyers. What happens to them? What happens to them? So I think, Honourable Speaker, it is advisable that Chairman Mao and Executive, you use other reasons for delaying the release of Dr. Besigye other than a decree.
And as we talk about the delayed release or transfer to the civilian court, I asked you, under what legal regime, legal basis, are you using to keep him there? We are not saying that Dr. Besigye is clean. He could be having a case to answer. He could be having a case to answer. But he should be taken to the proper court for him to be able to answer. Under what legal regime?
Madam Speaker, I think it is obvious that when you have been remanded by a court, and the court-martial is a court, it is only the boundaries of the court-martial that have been delineated by the Supreme Court. The court-martial has not been abolished. The court-martial has not been abolished. The court-martial is the one that remanded Colonel Kizza Besigye. Now, the release of Colonel Kizza Besigye will be ordered by the court, the appropriate court, when he is taken before that court.
Honorable Mao, when you look at Article 23 of the Constitution, protection of personal liberty, no person shall be deprived of personal liberty except in any of the following cases: in execution of the sentence or order of the court. Now here, the court ordered that Dr. Besigye should be what? Released. Now you're depriving him his liberty.
Madam Speaker, first, I hope this Parliament is persuaded that we did our duty as the Ministry of Justice. We did our duty. We responded very quickly because these letters which we wrote were about the Supreme Court. Now, the Supreme Court did not order the release of anybody.
There's an order from Honorable.
Thank you, Madam Speaker. Madam Speaker, I'm at pain that we are in arguments with the Minister of Justice. We're supposed to be the custodian of the law of this country. We are here, instead of the Minister of Justice coming here to tell us the law is supposed to do this, and this is what we are doing, is standing the other side to defend what is undefendable, Madam Speaker. We expect the Minister of Justice to behave what the Parliament expects him to behave, much as you are appointed by the President. But if you are also coming here to behave like the chairman of the court-martial, we are at pain. We are at pain, Honorable Minister. We are at pain. Madam Speaker, is it in order for the Minister who is a member of parliament, to come here and instead of debating like a minister, is debating like the chairman of the court martial. Is in order, Madam Speaker.
Honorable members, we need to solve a problem. And the problem we need to solve is about an ailing person. And secondly, using a law which is not there to keep somebody in detention. When somebody is on pre-trial, Honorable Minister of Internal Affairs, under what instruments are you using to hold Dr. Kizza Besigye in prison?
Right Honorable Speaker and honorable members, I understand the background to this matter, and I don't envy the Honorable Mao for being in this position. But I want also us to be, as we seek a solution within the law, I think we have about 3 matters to address. There is the health aspect of Dr. Besigye, but also there is wait a minute, I think we should be civilized enough to listen to each other. There's also the issue of the exercise of rights and the extent to which you can go, which really is an individual discretion, in this case of Dr. Besigye. And then the last one are the processes to effect the court decision. So, Right Honourable Speaker, as we address this question, I would want us to reconcile all the 3, instead of, if I may say so, going back and forth, and we need to craft a solution around the 3. But for now, I want to report, like the Honourable Minister said, the health aspects of Dr. Besigye are being addressed. Yesterday,
no, Honorable Minister.
Yesterday.
Honorable members,
Yes,
just hold on, Honorable Ministers. Honorable Minister is bringing a very important point, that we need to get a way to solve this problem. And that is what we want. We want a problem solved. And is leading us to a better direction. Yes. Yes, Honorable Minister. No, Honorable Minister of Internal Affairs.
Right Honourable Speaker and honourable members, like I said, we need to reconcile all the 3. I had the occasion also to speak to Commissioner General, and he said yesterday they took the doctor to a clinic of his choice, and
Honorable members, I am still asking, under what, you know, I've asked a question. I am saying, under which instrument are you allowing to keep somebody in your cells? That is your property. Basically that. And that's what the Honorable Minister is saying. We need to sit down and reconcile and see how best this can be
Right Honourable Speaker, until the processes around effecting the court decision,
yes,
the doctor is still in custody according to the order that took him there.
Lop. Honorable members,
Right Honourable Speaker, I thank you. Right Honourable Speaker, this morning I had a meeting with colleagues on this side, and to be honest, we were getting increasingly concerned about this, our people-centered parliament, because these are matters of the people, and we are clearly getting agitated. I am glad, Right Honourable Speaker, that we are now in unison dealing with this matter, because we have raised it severally, and we did not seem to see an end in sight. We did not think that this people-centered parliament was appearing as such. Honourable Speaker, there's only two ways that somebody can be held in any government jail. One, when you have been convicted and sentenced, whether it be to life or whichever number of years, legally speaking. Number two is when you have been remanded by a court of competent jurisdiction. Those are the only two ways under which somebody can be in any government jail. It is not, as some have said, a hostel. It is not some kind of hotel or I don't know what. It is only those two legally provided for means. Honourable Speaker, we have asked again and again, after the Supreme Court decision, which rendered the court-martial